And welcome to Law and Life. This is an initiative by Senior Advocate of Supreme Court of India, Subodh Parkandiji, to discuss on the legal statutes and help us to understand court's reasoning behind any judgment. In this video, we will talk on a special Saturday sitting of Supreme Court. It is one of the interesting topics which all the law scholars and layman person want to understand. So, is it normal for the Supreme Court to hold a special sitting as it did on last Saturday? What was for consideration?
Uh, Sometimes, mm, Supreme Court in the past have held special sittings. I think, particularly when those accused, who have been uh, given death sentence, they last minute come for stay of uh, execution. Nithari accused, Nirbhaya accused, but accused in the Bombay blast case. So these, but here, the uh, state of Maharashtra has come. So that's the, as your question itself shows, it was a special sitting on 15th October 2022. It was a Saturday. So naturally, there was only one case, that is specially petition criminal diary number 33164 of 2022. It was listed as item 301 in court number 2 on that day.
So please tell us more about this unusual case that had to be listed on a holiday.
So I went through the record of proceedings of the Supreme Court of that day and the judgment, impugned judgment of the Nagpur bench of Bombay High Court, running into 101 pages, which was delivered on Friday, the 14th October 2022. Uh, there were two criminal appeals, criminal appeal number 136 and 137 of 2015. So I read these from the websites of Supreme Court of India and the Bombay High Court Nagpur bench. And on that basis, I have pieced together some answer to your questions. So I did not have the benefit of going through the judgment of the sessions judge, Gadchiroli. Gadchiroli. Uh, so, so I'm slightly handicapped.
So let us go and ahead with the episode from whatever limited material is available. That is the record of proceeding of the Supreme Court dated on 15th October 2022 and the judgment of Nagpur bench of the High Court of Bombay.
So here, respondents numbers 1 to 5 in the specially petition before the Supreme Court were accused in Sessions case number 30 of 2015, while respondent number 6, that is Professor G.N. Sai Baba, was the sole accused in Sessions case number 130 of 2015. Both the session cases were tried together, and a common judgment was rendered by the session judge Gadchirodi, and likewise common judgment was also rendered by the division bench of the High Court. The accused were charged for being members of an unlawful and banned organization named the Communist Party of India, Maoist, uh, popularly called Naxalites, and they were also accused of having hatched conspiracy to incite people in the district of uh, Gadchiroli to violence and wage war against the government of India, and thereby committing offences under sections 13, 18, 20, 38, and 39 of the Unlawful Activities Prevention Act 1967, read with section 120B of the Indian Penal Code. Prosecution examined 23 witnesses and produced 64 documents. The document mainly consisted of Naxalite literature, digital data, retrieved from 16B memory card seized from accused number 3, Him Mishra, and documents, photos, video clips retrieved from the electronic gadgets, that is hard disk, pen drives, DVDs, SD, CDRs, seized from the residence of accused number 6, uh, Sai Baba from Delhi, whom the trial court has held to be the think tank of all the accused. So the sessions judge, by his judgment dated 7th March 2017, on the basis of the evidence on record, convicted all the accused and sentenced them to long terms of imprisonment, including life imprisonment and some fines.
So then what happened to High Court?
So the High Court has set aside the Sessions Court judgment and order of sentences only on the ground that sanction under Section 45 of the Unlawful Activities Prevention Act was vitiated as far as accused number 1 to 5 are concerned. And since the sanction was given belatedly in the case of accused number 6, on that basis, the High Court discharged, not acquitted, discharged all the accused and did not consider or return any findings on the merits of the case.
And how did proceeding in the Supreme Court arise?
So, state of Maharashtra probably moved the Supreme Court on the same day, that is 14th October 2020. And the next day, the state government's SLP was taken up for hearing on a Saturday at a special sitting before a bench of Justices M.R. Shah and Bela M. Trivedi. From its 9-page order, it seems that hearing was fairly long and detailed. The Supreme Court framed 3 questions for its consideration, mainly that whether, having regard to Section 465 of the Code of Criminal Procedure, where the trial court has convicted the accused after detailed consideration of evidence on record, can the appellate court discharge them on the ground of lack of or irregularity in the grant of sanction, especially when no such plea was raised in the trial or no question was answered in the statement of the accused under Section 313 of the Code of Criminal Procedure. So on these questions, the Supreme Court has issued notice to the accused, returnable on 18th of December 2022. It has also, after hearing the counsel for the accused number 6, who had filed the appearance, after hearing the counsel, Senior Advocate Mr. Basant, it has also suspended the operation of the judgment and order of the High Court under Section 390 of the Code of Criminal Procedure. So all the accused have to remain in jail till the Supreme Court passes a final order.